Hi, Mr. Happ. Thanks again for the videos and all the background information that you shared. It was really helpful in helping me reach the recommendation that I would like to give you today on the ADR process. I also wanted to hit on the assumption that the architect is going to have an even recommendation or an evenly heard recommendation to the judge. And so I kind of am throwing that out there. I'm going to repeat a few of the interests that I heard you say. The first one being that you wanted to end the discovery process. That seems to be your number one priority. Other interests were time and cost, and getting to a binding settlement or dispute resolution. So based on all those things, I think collaborative law is the best option for you, and I'll explain why. First off, you're represented by attorneys, not by neutrals or facilitators that are trained in a process. So you have you go into a limited representation agreement. It'll be in writing. They'll explain they'll explain all the limits and protections that gives you. And the coolest thing about the process is that there's a disqualification clause, basically saying that if you don't reach a settlement, these attorneys can't represent you in future litigation. And the reasoning and the goal and how the whole structure of collaborative law is put together is to really encourage the parties to take that process seriously so that there isn't the need for future litigation. And then you also would have to find another attorney and all these other things. So it kind of gives you a good motivation to get that dispute settled. That's probably the most interesting factor of it because it is really why the process works. It's kind of the founding principle of why clients choose it, because they're kind of giving an all-in win-win goal. And so to keep that in the back of your mind. The reason that I chose this, honestly, was that it's probably the only one that discovery is fully stopped. They do ask that you do this open communication in a four-way setting, meaning that yourself and the attorney you choose and the architect and the attorney that they choose will be the people that are part of the process. And they ask that you be open and discuss whatever comes up or whatever communication needs to be disclosed. But you have protection there. A handful of states have come on with statutory protection, very similar to mediation protection. And the states that haven't, you still fall back on the attorney-client privilege under the American Bar Association guided rules. And so I think that those are good protections to address kind of your concerns of not letting the public know about what's being talked about and ending that discovery process up front. The other thing that's great about this is that you're going to get to a dispute resolution, or that's the goal, in a contract way. So, you've talked about the interest of not necessarily continuing a relationship, but continuing maybe a contract type of solution so that he could continue to work on the condo in Minneapolis without it being any sort of, like, you would leave. You can write all those things in there, that you not be on the premise or however you want. You can write apologies in there. You can do whatever but it's in a contract versus a judgment or something that a judge is arbitrating or deciding. And you're going to have an attorney that's zealously representing you and giving you good legal advice and doing all that. So it's just kind of a heads up in terms of what to expect and how that will go forward. The other option is if you don't get to a settlement, there's nothing limiting you from using another ADR process. And while that does add time and a little bit of cost, it's still going to be cheaper than litigation in the long run. And so it doesn't necessarily tie your hands that if you feel like what you need isn't being addressed in that contract kind of settlement area, that you can't go back and do arbitration and have a binding decision from a panel of judges or a panel of neutrals. So it doesn't limit you in that kind of thing. You can pair things up. But again, it goes back to the idea that it does address those three concerns in terms of discovery, time and cost, and a settlement that offers you the potential to keep working with the architect, but basically just on a kind of worker or a contract for just a single job versus anything else. So I hope that addresses your concerns. I am open to any feedback if I misaligned any of those interests or if I'm not understanding something in terms of what the judge needs. And I hope to hear from you soon. Thank you.